You know, on behalf of the family, we do appreciate the predicament the ODPP finds itself in. We expected this matter to have been concluded so that the family can have closure. The mother wants to know what happened to her son. The public want to know what happened and what is the decision of the court. You know, I also appreciate the predicament of the judiciary in providing for infrastructure to allow the courts to sit. And I'm sure on Friday, the Judicial Dialogue Day, this will be one of the questions that will be asked to the judicial officers. And there might be no answer because the public is complaining of delay of cases moving to court, but that delay is occasioned by failure to supply the infrastructure to judicial officers. Your Honor, we urge that the court looks at an available date, the earliest time possible, so that this matter is heard and determined. It is a matter where the deceased was buried twice. Buried, exhumed, then buried. Very traumatizing. John, I will urge that if the court looks at its data, prioritizes this matter, some of the witnesses here are public figures who still the name or the tag that they are the killers has haunted them and interfered in their professional careers. We urge that the court, on our part as family, we are available at any time so that this matter rests. If the dates will be available next week, we'll try as councils to fix ourselves so that we complete this matter for once and for all. The cry of the family is that let there be closure. The earliest time the court can accommodate us and when the infrastructure can be available. Thank you, Your Honor.
For hearing of an inquest, the prosecution has indicated that 3 witnesses are present and that they were ready to testify. However, the objection has been raised by the defense, stating that they were not informed earlier of the witnesses who would be testifying, so that they'd be able to proceed. And there's also lack of an equipment, which is a screen for showcasing the videos of the scene. I have considered carefully the objection. This being an inquest of a public interest, the court is alive to the fact that there are many participants and that reasonable preparation is required for the witnesses to testify. The court also takes judicial notice of the fact that this matter is of public interest. More importantly, where one family as stated by Mr. Omari, the deceased is entitled to timely closure, and that unnecessary delay would prolong their anguish and undermine public confidence in the justice process. On the issue of facilities, the court acknowledges the concern raised regarding the absence of a screen to display visual material. I would not wish to dwell much into that, but as it is, the court operates within budgetary constraints. Regrettably, not all courts are adequately equipped with modern facility. The shortcoming is not deliberate, but it's attributed to the limited resources that we have. We express regret for the inconvenience caused. We will endeavor to ensure that the said facility is available and ensure that the case is disposed of in a timely manner to balance all the competing interests, including fairness to the defense, public interest, and the need to avoid undue delay in an inquest. Therefore, we'll adjourn the case for today. The prosecution is directed to notify the defense in advance of the witnesses to be called on the next hearing date and to indicate the nature of any visual or documentary evidence to be relied on. Therefore, we'll take out the matter out of today's course list and we'll agree on a date when to return to court.